Imagine being in court. A witness claims they've been injured in a bus accident, but the way they prove it might just hand you the case. It happened to a famous trial lawyer. Let me tell you how it went down. This is a story from Jerry Spence, one of the most renowned trial attorneys. He found himself up against a witness who had claimed that a city bus accident had left him with an injury to his arm. What happened next? Well, let's just say it was an unexpected twist. Story 1. The witness took the stand, asserting that after the accident, he couldn't lift his arm higher than a few inches. Jerry, ever the skilled lawyer, asked him to show the jury exactly how high he could raise his arm. The witness barely managed to lift it, and it looked painful. But then, Jerry turned the tables. He asked the witness, "Can you show the jury how high you could lift your arm before the accident?" What happened next was unbelievable. The witness, without thinking, raised his arm high above his head, effortlessly. And with that simple, unintentional move, the case was over. The jury saw it, and they laughed. That was all it took. Jerry had won. Sometimes the biggest help in court comes from your opponent. Story 2. Domestic violence case. The landlord was trying to evict the woman, claiming that she had violated the lease by calling the police during the abuse. But the law was on her side. Victims of domestic violence have specific protections. My argument was simple. The woman couldn't be evicted under the Violence Against Women Act, VAA, especially since the property was HUD subsidized, and Maryland law protects domestic violence victims too. Then in court, the landlord's lawyer made a huge mistake. During his opening, he described in vivid detail how my client had been beaten, the police had been called, and an ambulance had taken her away. It was devastating to hear, but he had just proven my case for me. I stood there, silent, letting the words sink in. When the judge turned to me and asked if I had anything to add, all I could do was say, "No, Your Honor. I believe opposing counsel has said everything that needs to be said." The judge smiled, and my client was spared eviction. Sometimes, it's the other side's words that help you win. Story 3. Foster care and guardianship battle. The situation felt like an uphill battle from the start. My family had taken in a foster child, a girl who had been through more than most could imagine. She had been subjected to years of emotional and physical abuse by her birth mother. The state had required that she stay in touch with her mother, hoping to eventually reunite them, but every interaction only seemed to tear her down further. Despite everything, my parents worked hard to create a safe and supportive environment for her. She blossomed under their care. She became one of the strongest, most resilient people I know. But the state had plans to return her to her birth mother. The thought of her being sent back to that toxic environment was unbearable. So my parents fought for guardianship, knowing it'd be difficult. Here we were, a family that wasn't even blood-related, trying to claim custody of a child who still had a real mom. What happened in the courtroom was unexpected. Her birth mother, perhaps sensing defeat, decided to represent herself at the guardianship hearing. I wasn't in the room at the time, but I listened to the audio recording, and it was unbelievable. She kept contradicting herself during cross-examination. At one point, she admitted to emotionally abusing her daughter, but tried to justify it, saying it was all because the girl was being difficult. The worst part, she testified that she never hit her daughter with a wooden spoon, claiming she only tried to hit her and missed. Then she went on to demonstrate the exact spot where the spoon had hit on the doorframe. It was surreal, watching her unravel her own case. It was as if she was giving us all the ammunition we needed. Needless to say, we won the guardianship. My sister was free from her birth mother's grasp, and she would never have to face that woman again unless she chose to. The court had done its job. Story 4. The construction permit case. We were dealing with a city that had denied a permit for heavy modifications on a house. The reason: the house could supposedly be seen from a historic church's bell tower. The city claimed it was a violation of preservation laws, and the modifications would disrupt the aesthetic of the landmark. But here's where things took a turn. To back up their claim, the city showed us a 366-degree picture from the top of the bell tower, clearly trying to demonstrate that the house was visible. We had our doubts. Our team, however, noticed something crucial. The house wasn't visible from the bell tower. In fact, it was blocked by a row of other buildings. So we calmly pointed that out to the city. Within hours, the permit was greenlit. It wasn't some grand courtroom drama, but it was satisfying. A simple, clear observation, one that the city failed to make, had the tide in our favor. Sometimes, the smallest details can win the day.
Vape them.
Story 5. The insurance fraud case. I was once involved in an insurance fraud investigation. The case centered around a roofing worker who had been collecting compensation benefits, claiming he couldn't work due to injury. The problem: we had hours of video footage that clearly showed him working on roofs, despite claiming he couldn't. The issue for me, though, was that the video didn't show his face clearly enough. It was more of a side shot, and he was wearing a hat and a beard, making it difficult to positively identify him. Without a clear ID, the case could easily be thrown out. I was preparing for a battle, knowing the claimant's attorney would try to challenge the video footage, but when the hearing started, something surprising surprised. The claimant's attorney agreed to stipulate that the person in the video was in fact their client. It was like handing us the case on a silver platter. From there, the defense lawyer made a huge mistake. He kept questioning me about roofing techniques, which was completely irrelevant to the case. I simply refused to answer. Eventually, the judge grew frustrated with the defense lawyer's persistence. The case was cut short, and the claimant had to repay the compensation benefits he had wrongfully claimed. It was one of those cases where the other side's blunders made it an easy win. Story 6. The financial mistake case. I was a student when I had to face a legal battle over a financial mess-up. I had followed the advice from the university's legal support team, who said I didn't need a solicitor. But when I went to court alone, the judge immediately postponed the case, insisting I get more legal counsel. As I stood there, completely unsure of what to do next, the opposing party's solicitor caught me outside the courtroom. He quietly pointed out a major flaw in the financial paperwork, something that would tip the case heavily in my favor. He didn't have to do it, but he did. He winked at me. At the second hearing, I showed up with everything corrected, went through the motions, and the judge threw out the entire case. My opponent, the solicitor, was the unsung hero who saved me a significant amount of money, around £9,000. Story 7. The misdemeanor possession case. This was one of those cases that felt like it had no chance from the start. A young man had been arrested for possession of a controlled substance. Pills found in a prescription bottle in the center console of his mother's car. The bottle was in her name, but the prosecution insisted that this was enough to charge him. The defense seemed obvious to me. It was a complete misunderstanding, but the district attorney was adamant about pursuing it. During trial, the DA called the case a circumstantial evidence case. I knew this was my moment. I stood up during my closing statement and projected the jury instructions. I pointed out that in a circumstantial case, if there are two possible explanations, one pointing to guilt and the other to innocence, the jury must acquit. The jury deliberated for only a short time, and my client was acquitted. It was one of those moments where the law worked exactly as it should, and it felt incredibly satisfying to see justice prevail. Story 8. The ineffective counsel case. This was a case that seemed like it would be a tough one for us, but it turned into an unexpected victory, thanks to the opposing lawyer's complete lack of preparation. Our client was claiming that his previous lawyer had been ineffective during his trial, arguing that the old lawyer hadn't asked the right questions or communicated properly. We were preparing our case thinking it would be a hard fight, but then the response from the opposing counsel changed everything. The former lawyer argued that he had been ineffective because he hadn't had time to prepare for the case, only reviewing it the morning of the trial. This was a bold claim considering the lawyer had been assigned the case months before the trial. It was essentially an admission of failure. I immediately pointed out the absurdity of this argument in court. During the trial, we unsubtly asked the judge, "Isn't this the definition of ineffective counsel? Not giving enough time to prepare?" The courtroom went silent. There was no more defense to give. The case didn't last much longer, and we won. Story 9. The district attorney's slip-up. I once had a district attorney make a huge mistake that ultimately led to my victory. I was involved in a case defending my client against financial claims from a separate estate. It seemed like a standard case, but then the opposing attorney, without realizing it, made a huge slip-up. During the trial, the district attorney indicated to the court that if the defense counsel had included a certain argument in his motions, it could have been valid. I couldn't resist. I interrupted him with the exact page number and heading where that argument was already clearly laid out in our documents. The DA's face turned bright red. There was no way to recover from that one. It was a small moment, but it completely undermined their credibility. That slip-up contributed to our win, and we walked out victorious. Story 10. The mysterious business valuation. I was involved in an estate case where the valuation of a business was at the center of a legal battle. The business had been sold years ago, and the court had to determine if the valuation was reasonable at the time. The issue was complex. So much had changed over the years, and many of the key people involved in the business were either dead or gone. The opposing counsel brought in a high-priced expert witness, claiming the business should have sold for much more than it did. According to them, the business had been undervalued by millions. But then we uncovered something crucial. It turned out that this same expert had done the 1996 valuation of the business. The very one that they were now trying to argue was incorrect. We hit them with a simple question: is your current valuation wrong, or was your original one wrong? The expert was caught off guard. He admitted that the 1996 valuation was based on the information available at the time, but he claimed that his current valuation was somehow more accurate, despite lacking the original documents. The judge saw through this nonsense and ruled in our favor. The expert had failed to provide any reasonable explanation for why his valuation should now be considered more accurate. It was a perfect example of the other side sabotaging its own case. Story 11. The custody battle with a twist. One of the most bizarre moments I've ever encountered in a courtroom was during a custody case where the father claimed he had a right to smoke weed around his children. It wasn't just that he smoked in front of them, it was the absurdity of his argument. When I asked him if he regularly smoked around his kids, he responded that he only smoked weed, not tobacco. He proudly declared that he followed the law of the streets, not the authority of the court. This claim made my job easy. Not only was it a violation of state law, but the man was openly admitting that he didn't care about following court orders. Needless to say, the judge didn't take kindly to his approach. Mom got full custody of the kids, and the father was arrested after an altercation outside the courtroom. Story 12. The fraudulent prescription case. My wife, a public defender, was once working on a case where the defendant was accused of filling fraudulent prescriptions. The evidence against him seemed strong. Surveillance footage of him filling a prescription using his own ID, along with a grainy video showing a person who looked like him at the pharmacy. However, the defendant maintained that someone had stolen his ID and was using it to get the prescription filled. It was a hard story to believe, especially since he never reported the ID as stolen. But then, during the trial, something strange happened. The prosecution brought in the pharmacist who had flagged the prescription. When asked if she recognized the person who filled the prescription, she hesitated before admitting that she did not. This was a huge moment for us. The witness wasn't sure about the identity of the person, and without that certainty, the case couldn't hold. We managed to get the records excluded based on the failure of the witness to prove the defendant was the one who committed the fraud. Story 13. The fake contract case. I had a case once where the opposing party presented a contract that was supposed to be signed by my client. The problem was, the contract was barely legible. It looked like a terrible copy, almost as if someone had photocopied it multiple times and passed it off as the original. The other party insisted that this contract was the same as the original one, even though it was clearly altered. But here's where things got interesting. The contract had the wrong party's name at the top, and the date of the signature didn't match the date my client had actually signed the original document. It was obvious that the document had been forged, so I raised this issue in front of the judge. But the opposing party kept insisting that everything was identical except for the names and dates. The judge, understandably, wasn't impressed. In the end, I pointed out that the person presenting the contract had a history of fraud. It wasn't just a casual accusation, it was backed up by his criminal record. The judge wasted no time in ruling in our favor. Case closed, and no further argument was necessary. Story 14. The lawsuit over the tree. When I was around 5, my parents explained to me a situation that seemed so bizarre, I can barely believe it happened. A man tripped over a tree branch that wasn't even on our property and claimed my parents were responsible for his injury. He came to court with a mountain of evidence: hospital bills, psychological testimonials, photos of his slow recovery. The whole thing seemed ridiculous because the tree wasn't even ours, but this guy and his lawyer were making it sound like we were to blame. The day in court came, and the opposing lawyer kept insisting that it was our tree. Finally, after some back and forth, the lawyer showed a photo of the tree, asking my parents, "Is this your tree?" To everyone's shock, it wasn't. My parents looked at the picture and said, "No, that's not our tree." The opposing lawyer, frustrated, insisted they were looking at the wrong tree, but after showing them a photo of the actual tree in question, it became clear. The case was dismissed, and we walked out of the courtroom completely dumbfounded. All's well that ends well, right? The story 15. The bamboo insurance case. There was a man suing for insurance money after allegedly chopping off his fingers while cutting bamboo with a machete. He claimed it was an accident, but there was a glaring problem. He couldn't reproduce the situation in court to save his life. The plaintiff's attorney tried to demonstrate with a rolled-up sheet of paper how the accident had happened, but no matter how he tried, he couldn't align the position of the fingers with the angle needed to match the machete's cut. Finally, the attorney had to admit that the only way to make the accident match would be if the plaintiff had extended his fingers deliberately over a surface, essentially hacking his own fingers off. It was clear to everyone that he had injured himself intentionally. After this disaster of a performance in court, the judge ruled that expert testimony was required to fully determine what had happened, and eventually, the case was dismissed due to self-mutilation. Sometimes all it takes is a bad performance to destroy a case. Story 16. The landlord dispute. My parents once got caught up in a legal battle with a landlord after they rented a house. It seemed like the perfect place. They did the usual walkthrough, signed the lease, and moved in. But when they arrived with all their belongings, the house was a complete disaster. The landlord had left his own belongings scattered around and the place was filthy. There was urine on the floor, garbage everywhere, and it was clear that it hadn't been cleaned before they were supposed to move in. They called the landlord, expecting him to fix it, but instead, he demanded that they clean the house themselves or he would keep their deposit. He even promised to pay for the first tank of oil for the house, if they cleaned up. This led to a whole mess of back and forth texts, phone calls, and harassment. Eventually, it was time for court, and my parents showed up with all their evidence. Photos, videos, texts, the lease agreement. The landlord, on the other hand, had only a contract that was clearly different from my parents' version. The date on his contract was even wrong. The judge, after hearing everything, turned to the landlord and said, "You're a special level of stupid." He didn't just rule in my parents' favor, he mocked the landlord for his incompetence and ordered him to pay up. The landlord never paid, filed for bankruptcy, and later tried to restart his business under a different name. It's funny how karma works. Story 17. The civil litigation struggle. In my practice, I often dealt with civil litigation, where you would expect lawyers to be on equal footing. But surprisingly, I often found myself up against parties representing themselves. People who were otherwise intelligent, but had no idea how to navigate the legal system. One case that stands out was a deposition where we had to deal with a company's unpaid invoice. The defense claimed they hadn't paid because they heard the company was going bankrupt. The only problem was the company wasn't bankrupt, and that defense didn't hold water. But as I examined the case, I saw a pattern. There was a clear lack of understanding about the law on the opposing side. They tried to argue that non-payment would be acceptable under bankruptcy protection laws, but they were completely wrong. In the end, I was able to easily dismantle their defense and win the case, showing once again how important it is to understand the law if you plan to represent yourself in court. Story 18. The civil litigation opponent. There was one attorney I had to face again and again over several years. Brian. He became of a legend in our firm for the number of cases he lost that he could have easily won. Brian had a knack for sabotaging his own case. One particular case stands out. The evidence clearly pointed to our client being at fault. It was one of those cases where it felt like settlement would have been the best option for everyone. But then Brian introduced a witness voicemail, which we had no knowledge of. We were all intrigued, but when we listened to it, we couldn't believe it. The voicemail made the plaintiff sound completely insane, rambling incoherently, and swearing about unrelated things. Instead of questioning the voicemail's relevance, we allowed it to be entered as evidence, and it only helped us. The plaintiff's case was completely undermined by that message, and we won the counterclaim easily. It was one of those rare moments when the opposing counsel actually handed us a case. Brian's carelessness and inability to read the room made him lose yet again. In a way, we couldn't help but feel a bit sorry for him, but we were too happy with the win to dwell on. Story 19. The ex-boyfriend lawsuit. This was one of the most bizarre small claims cases I've ever seen. A man who had dated my mother for a while ended up taking us to court after the relationship ended. He was Nguer, and he had an itemized list of every single thing he'd ever bought for us, down to the last cheeseburger and Kit Kat. He also tried to charge us for house repairs, some of which were terrible. He had once tried to fix the sink, but ended up destroying the main drain pipe. But what was worse, he kept trying to remind us of all the expensive things he'd bought for us, as though we owed him something. When it was time to present his case, he started listing all the things he had bought for us, and saying, I should be repaid. The judge listened carefully, and then asked him a simple question. Did you ever tell them these things were loans and not gifts? The man hesitated and then said, no, but that's just how it is. Everyone knows it. The judge responded, well, that's not how I see it, and dismissed the case without a then word. It was a textbook example of someone overestimating the value of their own generosity. The man left the courtroom in defeat. Story 20. The reckless conduct case. This case was one I didn't personally prosecute, but I was in the gallery watching the whole thing unfold. The defendant was accused of reckless conduct with a deadly weapon and criminal threatening after allegedly waving a gun at 2 Dairy Queen employees and firing it in the air. He was the manager of the Dairy Queen at the time. The prosecution couldn't produce the 2 employees who were supposedly threatened. Both had been subpoenaed, but didn't show up. The judge didn't grant a continuance, so the state went ahead with their case without the key witnesses. When it was the defense's turn, the defendant took the stand. He testified that he wanted to scare the employees as a joke and admitted to brandishing the gun. On cross-examination, he gave more details about how he had fired the gun. It was an incredibly odd turn of events. He was essentially convicting himself. The judge took his time delivering the verdict, pointing out how rare it was to see a defendant accidentally incriminate himself so completely. The verdict was obvious, and as the judge read it out, the defendant fainted and collapsed on the courtroom floor, hitting his head on the defendant's table. The entire courtroom was shocked. Emergency personnel were called, and the defendant was taken out on a stretcher. Meanwhile, the defense attorney, who looked about 60, seemed just as stunned and almost in need of medical attention himself. What was even stranger was that the defendant had been facing deportation, as he was a convicted felon. The judge's verdict sealed his fate. He would be sent back to his home country. The whole trial was a strange mix of legal blunders, bad luck, and pure drama. Story 21, The Ineffective Counsel, Part 2. I once worked on a case where the previous lawyer for our client had been accused of ineffective counsel. The argument was that the lawyer didn't ask the right questions or communicate properly with the client, which left them at a disadvantage. When we received the complaint from the other side, it didn't take long to see where things went wrong. The former lawyer had only reviewed the case the morning of the trial. This wasn't just a mistake, it was a clear violation of the basic duties of a lawyer. We approached the judge with this information and essentially asked, "Isn't this the textbook definition of ineffective counsel?" The courtroom was silent, and the judge's face said it all. The opposing lawyer had nowhere to go with his defense. The trial didn't last much longer, and we came out victorious. Story 22, The Reckless Gun Incident. This was a case I saw from the public defender's side, and it was something I'll never forget. A man had been charged with reckless conduct with a deadly weapon after allegedly brandishing a gun at 2 employees in a Dairy Queen and firing it into the air. It was a serious charge, but the prosecution had witnessed. The defendant, who was the manager at Dairy Queen, testified on his own behalf, explaining that he had simply wanted to scare the employees as a joke. But his testimony didn't stop there. Under cross-examination, he went into too detail, explaining how he had aimed the gun, how he fired it, and even how he had positioned it in the air. It was clear to everyone in the room that the defendant had just convicted himself. The judge, after what seemed like an eternity of silence, finally delivered the verdict, pointing out how rare it was for a defendant to incriminate themselves so thoroughly. And then, in the most bizarre turn of events, the defendant fainted, crashing into the defendant's table as he collapsed. It was a strange, dramatic moment that added a surreal ending to an already unusual trial. Story 23, The Contract Forgery Case. I once handled a case where the other party tried to pass off a contract as legitimate, claiming that my client had signed it. The only problem, the contract was a terrible copy, barely readable, and looked like it had been manipulated. The posing lawyer was confident, assuring the court that the contract was identical to the original, despite the glaring issues. He argued that the only difference was the party's name on the top and the date at the top of the document. But I could see right through his story. I pointed out that the terms of the contract were completely different from the Vernon, and my client had never signed it. The best part, the person presenting the contract had a criminal history of committing contract fraud. I didn't hesitate to bring it up. When I showed the court the man's prior conviction for fraud, the case was dismissed. The judge ruled swiftly in our favor, and it became clear that the opposing counsel had no case to begin with. We had a neighbor who decided to sue us for damages after tripping over a tree branch in front of our house. The tree wasn't even ours. It was on the sidewalk, and it was the city's responsibility to maintain it. The man showed up to court with a mountain of evidence, hospital bills, photos, and all sorts of paperwork. He even had psychological evaluations claiming that the accident had caused him long-term trauma. It was ridiculous, especially because we had nothing to do with the tree. When the opposing lawyer tried to make their case, they asked if the tree was ours. My parents looked at the photo and said, "No, that's not our tree." The lawyer insisted that it was, showing a blurry photo of another tree, but the tree in question was completely different. At that point, my parents' lawyer hired the actual photo of the correct tree, and the case was dismissed on the spot. It was a huge win for us, and my parents couldn't help but laugh at how the whole thing fell apart because of one simple mistake. Story 25, The Bamboo Machete Injury. This was one of the most absurd cases I've ever encountered. The plaintiff was suing for insurance money after supposedly chopping off his fingers while cutting bamboo with a machete. He claimed the injury was accidental, but something about his story didn't add up. During the hearing, the opposing attorney tried to demonstrate the accident using a rolled-up sheet of paper, trying to mimic the angle at which the plaintiff allegedly injured himself. No matter how he tried, it was impossible to recreate the situation. The defense attorney tried to argue that it was a freak accident, but the only scenario that fit was if the plaintiff had deliberately extended his fingers across the bamboo stalk to hack at them. The judge immediately saw through the poor performance and decided that expert testimony was needed to confirm the injury. In the end, the judge ruled that the injury appeared to be self-inflicted, and the case was dismissed. It was a perfect example of how a poorly constructed argument can easily unravel in court. Story 26, The Landlord's Storage Clause. My parents once found themselves in a legal battle with their landlord after they rented a house. It was supposed to be the perfect move until they arrived and found the house in complete disarray. The landlord had moved his personal belongings into several rooms and had left the house in an unlivable state. The landlord refused to do anything about it, even suggesting that my parents clean up the house themselves. It was outrageous. And after some back and forth, the case ended up in court. We had video footage, photos, and text messages to back up our claims, while the landlord only had a contract that was completely different from ours. The landlord's contract had a bizarre clause stating that he had the right to store his belongings in the house and that the tenants were responsible for all maintenance. The kicker, the date on his version of the contract was the date my parents actually moved in, not when they signed it. When the judge heard all of this, he was furious. He mocked the landlord for his ridiculous behavior and told him he was a special level of stupid. The case was ruled in my parents' favor, and they were awarded everything they were entitled to. To add insult to injury, the landlord later filed for bankruptcy and tried to reopen his business under a different name. One particular case stands out, where the other party was handling their own defense. They were sharp in some ways but had absolutely no clue about the legal system. We were disputing unpaid invoices, and the other party had claimed that they didn't pay because they had heard the company we were suing was going bankrupt. The issue? The company wasn't bankrupt at all, and it was an invalid excuse for not paying their debt. The opposing parties' arguments were weak from the start, and as I cross-examined, it became clear they didn't understand how bankruptcy laws or even basic contract terms worked. It was a textbook example of why representing yourself can backfire. The case was in their favor, and the other party left the courtroom looking completely defeated.